Under God, 7th edition, updated and revised by William C. Hendricks. Chapter 11, The Constitution, Federal, Changeable, Supreme. Important ideas to look for. Powers not given to the federal government belong to the states. The Constitution can be changed to meet new needs. The Constitution is the supreme law of our land. And after the states ratified the Constitution, it became effective. Article 4. The States and the Federal Government. Section 1. Public Records. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved, and the effect thereof. Article 4 tells how the states must get along with one another and with the federal government. During the time of the Articles of Confederation, there had been many quarrels between states. The Constitution needed to provide domestic tranquility to provide this peace at home. The federal government needed the power to regulate the relations between states. Although the federal government has many powers, the individual state also has much power over their citizens. In fact, the states have this power first. The federal government was created by the states. The delegates to the Constitutional Convention were elected by the states. The Constitution was ratified or approved by the states before it went into effect. All power not delegated to the federal government by the states is still held by the states. The men who drew up the Constitution provided in Section 1 of Article 4 that each state must accept the public acts, the laws, the birth and marriage certificates, the court decisions of all others. These men realized the need for unity and knew how unity had helped them win the Revolutionary War. This part of the Constitution helps the states work together. Section 2, Privileges and Immunities of Citizens. The citizens of each state shall be entitled to all privileges and immunities of citizens in other states. When you are in a state of which you are not a resident, you will be treated just like the resident of that state. If the residents of that state pay a sales tax, while you're visiting there, you must pay the same sales tax. You may have most of your privileges too. A few of the privileges, such as the right to vote, can be yours only after you have settled there. Some states allow you to vote after you have lived within their boundaries for 6 months. Other states require a residence of 1 year, and a few require as much as 2 years. A person charged in any state with treason, felony, or other crime, who shall flee from jurisdiction and be found in another state, shall on demand of the executive authority of the state from which they fled be delivered up, to be removed to the state having jurisdiction of the crime. If a person who is accused of a crime in one state flees to another state, the police of the state into which they escaped may arrest him and hold him in jail. For example, if he's accused in Washington and flees to Idaho, the police in Idaho may arrest him, but the governor of Washington may ask the governor of Idaho to return the prisoner. This is called extradition. In a few cases, a governor has refused because he felt that the person was unjustly accused or would not get a fair trial, but usually the prisoner is returned. This portion of Section 2 refers to the slaves and provides that slaves who ran away from their masters into another state, regardless of the state slavery laws, had to be returned to their owners. Since Amendment 13 has freed all slaves, this part of the Constitution no longer has any effect. Section 3. New states, territories, and public lands. New states may be admitted by the Congress into this union. Land added to the United States is usually first called a territory. When a territory is grown in population, it may apply for statehood. Congress must approve the Constitution of the new state and pass an act admitting the new state into the Union. But no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states or parts of states without the consent of the legislatures of the states concerned, as well as that of the Congress. A new state cannot be formed within the borders of another state or states unless the state's legislatures and Congress approve. This happened only once when the western part of Virginia wanted to stay with the North during the Civil War. When Virginia joined the South, Congress passed a law that made it possible for West Virginia to become a separate state. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of the other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. The claims of states to Western territory had been one reason the state quarreled during the time of the Articles of Confederation. To avoid such trouble in the future, the Constitution placed the control of the territories outside the state boundaries under the control of the national government. Other property includes the national forests, parks, forts, and public lands of the United States. Congress may pass laws to dispose of, that is, sell public land or national forest timber. Only Congress has power to control national property. Section 4. Protection of these states. The United States shall guarantee to every state in this Union a republican form of government and shall protect each of them against invasion. Our national government is a republic. That is, its laws are made and enforced through elected Congress and President. Our states also must be republics. The people must be allowed to make their state laws through their elected representatives. If a dictator should try to take over a state, the national government must step in and restore the rights that God has given to the people. And on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. Our national government must also help maintain order in a state when the state itself cannot keep order. Many times in our nation's history, the President has sent federal troops into a state to maintain order. For example, President Eisenhower sent troops to Little Rock, Arkansas, at the time when black students first enrolled in the high school. President Kennedy also sent troops to Oxford, Mississippi, when the first black student entered the previously all-white University of Mississippi. By helping to maintain order in times of tension, when riots or other types of crisis occur, our national government can serve as a servant of God for good to the states, as well as to the individual citizens. Article 5. Provision for amendments. The Congress, whenever two-thirds or both houses shall deem it necessary, shall propose amendments to the Constitution, or, on the application of the legislatures of two-thirds of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of three-fourths of the several states, or by conventions in three-fourths thereof, as the one or another mode of ratification may be proposed by the Congress. The men who drew up the Constitution realized that the new form of government could not meet all the unknown situations of the future. Only God knows what the future of our country will be. Consequently, the drafters provided that the Constitution could be amended or changed to meet unforeseen needs. Our Constitution has been amended 27 times. Amendments can come from two sources. They may be proposed by Congress, or by a national convention called a Congress at the request of the legislatures of two-thirds of the states. So far, all the amendments have been proposed by Congress. After both houses of Congress have approved the proposed amendment, they must send it to the states for ratification or approval. Proposed amendments can be ratified in two ways, by the state legislatures or by the state conventions called for that purpose. All of our amendments have been approved by our state legislatures except Amendment 21. The possibility of amending or changing our Constitution is one of the basic principles of our government. Even if we do not like the law or part of the Constitution, we may not disobey or disregard it. God tells us that we must be subject to the governing authorities in Romans 13:1. We have a greater responsibility of seeing that our nation in its laws is under God. If a law is against God's law, we must work hard for the amendment of that law. If a law has been wrongly interpreted, we ought to do all that we can to correct the interpretation of it. Whenever a law is unfair, unjust, or even unnecessary, we must work for its improvement or removal. We should not hastily decide to disobey it because we don't agree with it. Provided that no state, without its consent, shall be deprived of its equal suffrage in the Senate. No amendment could be passed before 1808 that would keep the South from bringing in slaves. No amendment could change the fact that direct taxes would be equally shared by everyone. No amendment may give one state more senators than those of another state. No state may be deprived of one of its two senators unless that state agrees to give up one of them. Here again, the Constitution protects the rights of the small states. Article 6. General Provisions. All debts contracted and engagements entered into before the adoption of the Constitution shall be valid against the United States under the Constitution as under the Confederation. Our nation had to pay its debts when the Constitution replaced the Articles of Confederation. At that time, we had a debt of about $80 million. Being in debt is no disgrace to any government, business, institution, family, or individual, provided the terms of the debt are honored. The United States government has assumed full responsibility for its debts since 1789. It has paid off these early debts, borrowed money to pay for heavy obligations, paid these debts, and borrowed again. To the credit of the United States government, it has never in 200 years defaulted in any of its financial obligations. Presently, the debts of our national government are owed to individual American citizens, to savings institutions, to life insurance companies and other corporations, and to commercial and Federal Reserve banks. Anyone may purchase United States savings bonds upon which interest will be paid. Other types of government units, such as cities, states, counties, and school districts, also borrow money at times and are responsible for their debt. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made of which shall be made under the authority of the United States, shall be the supreme law of the land. The judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The Constitution states that it is the supreme law of the land. Supreme law means that the Constitution is higher law than the laws of the states. Judges who work with state laws must promise to uphold the national laws even if the state laws contradict the national laws. The state laws must become secondary because the United States Constitution and laws made to develop it are supreme. This does not mean that the Constitution is above the law of God. The Constitution is supreme over a state's laws, but God's is over all law. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. The officials of our government are required to take an oath that they will support the Constitution of the United States. As a citizen, you make a solemn promise to be loyal, faithful, and obedient when you pledge allegiance to the flag. An official has religious freedom just as any other citizen does. Therefore, no religious test may be given. Article 7. Ratification. The ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. When the men who drew up the Constitution had finished their work, the Constitution was not forced upon the people. Instead, the new plan was presented to the Congress of the Confederation. To the 13 state legislatures and to the people themselves, it had to be ratified or approved by the people through their elected representatives before it could go into effect. So, it was put into effect in the same way that it still works today through representatives elected by the people. Done in convention by the unanimous consent of the states, represent the 17th day of September in the year of our Lord 1787, and of the independence of the United States of America, the 12th, in witness thereof we have hereunto subscribed our names, George Washington, President and Deputy from Virginia. These 38 other delegates from 12 states also signed the Constitution.